Clementi, the Chief Executive of 10, the Education Network. Nick Ruskin from K&L Gates in Melbourne will be discussing the vexed question of long-term injured workers and return to work at our upcoming Melbourne Employment Law Conference on the 16th and 17th of March this year. Nick's with me today for a sneak peek at what he plans to cover in his presentation. Nick, first of all, thanks very much for joining us. When a person has been absent from work through illness for a significant period of time, putting it bluntly, how can you manage the termination of their employment?
Well, thanks, Rob. It's a vexing question, but there is a solution to it. You just have to go through a number of hoops. If someone's been off for a long period of time, if they're covered by workers' comp, then there are limitations on when you can end their employment, because there are protections under workers' comp legislation to leave a job open for a period of time, 6 to 12 months, depending on the jurisdiction. If it's not a workers' comp claim, then you've got to consider whether they've been absent for at least 3 months or a combination of 3 months in a 12-month period, and they haven't been on personal paid leave the whole time, because otherwise they will be regarded as still temporarily absent. And then if you're through those things, then the key issue is, can the employee perform the essential requirements of their job within the foreseeable future? And that really is a question that would be ultimately determined by medical evidence. That's what you need. You need medical evidence to come to a view that they can't do the key elements of their job. And foreseeable future is not very well defined, but it may be looking forward 3 to 6 months. Can they do their job? Will they be better enough to do their job? If they admit to themselves, to you, that they can't do it, then you're there. But otherwise, you need medical opinion. If their medical practitioner is not able to give an opinion, or gives an opinion that you want to query, then you are free to get independent medical advice, which is usually how these things end. You need an independent medical assessment which says they can't do their job because of their medical condition, and they can't do so within the next 3 to 6 months. That puts you in the best position to defend claims.
Nick, thank you very much. And if you want to hear more on this subject, particularly Nick's presentation, you can register for the conference by going to our website, www.tved.net.au. In the meantime, thank you very much for listening.